I'd like to introduce the Assistant Attorney General for the Department of Justice's Antitrust Division, Makan Delrahim.
Thank you so much, Karina, for all your work and for helping us coordinate this workshop. For nearly 3 years now, I've had the unique privilege of serving as the Assistant Attorney General for Antitrust at the Department of Justice. And on behalf of the Department of Justice, I want to welcome you to our workshop today. I also want to thank our esteemed panelists for the presentations and perspectives they will share with us over the next 2 days. Given these challenging times, I'm welcoming you to a virtual workshop rather than to one in the Great Hall of the Department of Justice, where we've held several of our earlier workshops on these matters. You may ask, what is our goal for this workshop? I have to say in one word, it's competition. Competition for the benefit of the American consumer, competition for the benefit of innovation, and competition for the benefit of the songwriters, composers, and the artists. I feel confident that this workshop will be informative and valuable to both the participants, the public, and us at the Antitrust Division. After all, it's not every day that great artists like Leanne Rimes, Pharrell, and John Bon Jovi share a stage with boring antitrust lawyers and economists. But artists, like all workers, creators, and innovators, benefit from competitive markets. So it is only natural that we should come together to discuss competition in music licensing. This workshop is part of the division's ongoing effort to promote competition in the music licensing industry. Those efforts began with consent decrees first secured as resolutions to antitrust suits brought by the Antitrust Division nearly 80 years ago. For students of history, that is almost 80 years ago. These decrees between the Department of Justice and two organizations, ASCAP and BMI, continue to govern music public performance licensing today. Like so many of you, I love music, and it has played a special role in my life. When I came to the United States as a refugee from Iran as a child, I didn't speak a word of English. The music on the radio nonetheless spoke to me. The Jazz Singer was the first movie I saw in the United States. When Neil Diamond sang about people coming to America without a home, but not without a star, he was singing to me, I felt. And I'm sure many Americans respond similarly to that song. That is the magic of music. It speaks a universal language. It can make us feel joy, can make us feel pain. Like nothing else, it can spark our imaginations and our memories. To this day, hearing Neil Diamond floods me with memories of my early days in America as a child. Not much else can do that. Each of us here has a song that transports us to a magic moment, evokes a feeling, or simply inspires us to carry on. Music, perhaps most profoundly of all, has the extraordinary capacity to inspire hope and bring us together in times of division. Many consumers of music today wouldn't recognize 8-track tapes, cassettes, or vinyl records, or even perhaps CDs. Technology continues to evolve how we enjoy our music. Digital streaming technology now gives us all access to almost any song, anytime, and anywhere. Some may recall the Spanish ship that sailed to discover America, the Santa Maria. It carried the flag of Queen Isabella that bore the words, quote, "Nothing further," because they believed Spain to be the furthest point west in the world. When they discovered the New World in America, the Queen ordered the flag repainted to read, quote, "More beyond." With new technology and new business models, we know there's more beyond for music. Congress has responded to various innovations with new laws, such as the Digital Millennium Copyright Act in 2000 and the Music Modernization Act just recently in 2018. Some of the rules that govern the music industry today, however, are quite old. The Justice Department's consent decrees with ASCAP and BMI, for example, first went into effect in 1941, the year the United States entered World War II with the bombing of Pearl Harbor. In that year, a gallon of gas was 12 cents, and the average cost of a new home was a little over $4,000. Americans listened to music on the radio or on phonograph players, which were becoming more affordable. And there was a robust market for sheet music sales. Music has happened in the way, much has happened in the way we listen to music since then. As Churchill famously said, quote, "To improve is to change, so to be perfect is to have changed often." While I assume that no one would accuse the Antitrust Division of being perfect, we have periodically revisited and changed our views on antitrust enforcement based on new market realities or new economic discovery. After the division's most recent review of the music consent decrees in 2016, the department issued a closing statement signaling that we might revisit the decrees after resolution of, among other things, uncertainty surrounding fractional licensing. About a year later, the Court of Appeals for the Second Circuit concluded that the BMI consent decree allowed for fractional licensing. After the Second Circuit's ruling, I began meeting with all interested parties about the decrees, and we invited public comment on the decrees again in 2019. As part of this process, we received over 800 comments from members of the public, academics, and many of the organizations represented by panelists here today and tomorrow. This workshop is part of our effort to ensure a vigorous public dialogue about the state of competition in music licensing, and specifically the ASCAP and BMI consent decrees. This inquiry into ASCAP and into the ASCAP and BMI decrees also is part of a broader effort across the division that began when I took this job to systematically revisit old consent decrees and determine whether they continue to serve the original purpose of protecting competition. Since 1979, the standard practice of the Antitrust Division has been to limit the period of consent decrees to no more than 10 years. Prior to that, decrees were often perpetual. Thus, when I became the Assistant Attorney General in 2017, consent decrees from as far back as the 1890s remained on the books. Among these many decrees, one of the oldest involving the music industry was a 1921 consent decree enjoining Oscar Kern and 5 co-defendants from operating the Retail Music Roll Dealers Association of Philadelphia. The Retail Music Roll Dealers provided music rolls for piano players. At the time, it represented a big bet against a rival technology that was starting to gather steam, the radio. In Mr. Kern's words, quote, "People will not be satisfied to hear music coming out of the air. They want the music right out of a piano or a talking machine in their own homes," end quote. Video might have killed the radio star, but the player piano consent decree was alive and well for nearly a century. We finally terminated it last April, about 13 years after Apple introduced the first iPhone. Another set of decrees involved coin-operated phonographs. The 1957 judgment, for example, prohibited a distributor of coin-operated phonographs from restricting their resale to certain people in certain geographic areas. We terminated that successfully last year as well. Through our decree review process, we have given decrees like these a fresh look. As a result, nearly 800 outdated judgments are now history, thanks to the hard work and dedication of the Antitrust Division staff and the courts that have acted on our requests. As we think about ASCAP and BMI decrees during this workshop, we are mindful of the priorities underscoring the judgment review initiative, that the free market, not enforcement by government decree, should be the default. Where consent decrees are necessary, they must be justified by the current competitive landscape or by tomorrow's, and not allowed perpetually to regulate an industry simply because they're the status quo. We're also mindful of valuable lessons we have learned through our enforcement actions. For example, Ticketmaster and Live Nation entered into a consent decree in 2010 in which they promised not to retaliate against concert venues for using competitor ticketing companies. When they broke those promises, we enforced that decree. We also strengthened the decree in multiple ways so that it would be easier to deter and detect violations going forward. These developments benefit American consumers and music fans alike. They also prove that consent decrees, when they are justified and well-defined, can be a valuable enforcement tool. We recognize that the ASCAP and BMI decrees affect the lives of many Americans, from those in the music industry to those who simply love listening to music. We also understand that the current music ecosystem has grown and evolved over many years in an environment in which the decrees have been in place. We therefore approach these decrees in an open-minded and balanced way, inviting comment and engaging with all stakeholders. These decrees deserve the utmost in careful consideration, but we also must recognize that consent decrees do not conduct music, but the market for music is conducted by these consent decrees. Ultimately, it is critical that songwriters, composers, and musicians enjoy the fruits of a free market for their creativity, as the U.S. Constitution provided through Article 1, Clause 8, and as intended by the Sherman Act. As ABBA put it, quote, "Nothing can capture a heart like a melody can. And without a song or dance, what are we?" Artists who give us those melodies and songs deserve economic liberty. They deserve the opportunity to pursue recognition and compensation consistent with the value of their work. That is the system our founders envisioned in drafting our Constitution when they provided copyright protection for creative works. I thank the artists and composers and the executives who will share their views over the next 2 days. And I thank all creative artists for enriching our lives and our souls with their music each and every day. We must ensure that America's unique combination of free expression and free enterprise can be an incubator for songwriters and musicians everywhere. We're all better for their creations. And as one of my favorite artists, Alicia Keys, counseled in her recent song, Underdog, keep on keeping it what you love. Now it's my privilege to introduce one of the greatest musical innovators of our time, Grammy Award-winning singer, songwriter, and global sensation who needs no introduction, Ms. Leanne Rimes. Thank you.